Good afternoon, ladies and gentlemen. This is, as you probably know, what they call the tort stream. We're going to be doing heavy-duty tort law, negligence law, wonderful stuff, and we have two very distinguished people with us. Ken Oliphant is director of the Institute for European Tort Law of the Austrian Academy of Sciences, and he's on extended leave from the University of Bristol, where he's a professor of tort law. He's held faculty positions at King's College London, Cardiff. He's written extensively in fields of English and European tort law, and I could go on. He will be our first presenter. Donal Nolan is our second presenter. He is the Pohis Foundation Fellow and Tutor in Law at Worcester College, Oxford, and a CUF lecturer, CUF lecturer in law at the University of Oxford. And he has taught tort, contract, international trade law, restitution, and commercial law, and has been a visiting professor in the universities of Florida and Trento. His interests are tort and contract, and he's published on a range of subjects in those fields, including nuisance product liability and liability for a psychiatric injury, liability of public authorities, and equitable estoppel. Our format is, I think, simple, and it can be adjusted to meet the needs of our speakers and our audience. We propose to first hear from Mr. Professor Oliphant, who is going to talk about principles guiding tort law and argue, as I understand it, for a more flexible approach than has sometimes been shown. Professor Nolan will then talk about the duty of care in a talk entitled Deconstructing Duty. I thought it might be best, but this is subject to what you wish to do, all of you, if we reserve questioning and discussion until both of our speakers have completed their interventions. However, as with in the interest of flexibility, should you have any burning question or not understand something or feel you really need to unburden yourself of something at the end of Professor Oliphant's talk, do put up your hand, and a short clarification or whatever, I'm sure, would be in order at that point. So without further ado, I will turn my mic over to Professor Oliphant.
Well, thank you very much. It's a huge honor and privilege to be in this session chaired by the Chief Justice, whose judgments I've always found extremely admirable, and quote several of them in the casebook I write on the English law of torts, providing a useful corrective to the errors of English judicial ways. It's also a great pleasure to be on a panel with my former colleague and good friend Donal Nolan, whose paper I've read with very great interest. I think it's an excellent piece of work, complementary to mine in lots of ways. So it probably is a good idea to save the question and answers till afterwards. And then one final preliminary comment, not related to the theme of my paper, but those of you who were at the Paisley Snail conference in Glasgow a few weeks ago will note that I am modelling the commemorative Donahue and Stevenson tie that I won in the raffle there. For this conference on challenging orthodoxy, my target is a particular approach to tort law that treats certainty as a fundamental legal value that properly shapes the development of liability principles. In my view, an excessive concern with certainty has been evident in recent decades in the judicial approach to tort cases in England. I'm not qualified to assess to what extent it's also to be found in other common law jurisdictions. The English commitment to certainty is manifested in a number of characteristics of the current judicial approach, which will form some sort of recurring theme of my paper. And they are, first, a strong commitment to an incremental method. Secondly, the instrumental use of policy arguments. 3, the pursuit of bright line categories of duty, limited duty, and no duty. And fourthly, judicial passivity in the face of unsatisfactory outcomes. In my paper, I make 2 main criticisms of the English preoccupation with certainty in tort law. First, that it results in incoherence. Secondly, that it's in fact counterproductive. It results in incoherence because the excessive weight attached to certainty produces outcomes that are at odds with fundamental principles and involves arbitrariness and inconsistency. It's counterproductive because the subject matter of tort law is inherently uncertain, and the attempt to render it certain in fact leads to the recognition of exceptions of ill-defined scope. The preferable approach, in my opinion, is to identify in broad terms the factors on which liability in tort rests and to assess them in the round on the facts of individual cases. The role of the Supreme Court, consequently, should be conceived as setting the parameters within which this weighing exercise is conducted and establishing the relative weights that are to be attached to the factors considered, rather than trying to lay down precise and detailed rules that lower courts are constrained to apply mechanically. So that's my paper in a nutshell. I'll first attempt to substantiate my claim that an undue preoccupation with certainty results in incoherence in the law, with reference to the 4 features I've sketched out already. The first is incrementalism. According to an influential dictum of Justice Brennan in the Australian High Court, the range of situations giving rise to a duty of care should be extended incrementally and by analogy with established categories. This approach reflects a fear of the uncertainty involved in the extension of existing principles of negligence liability to new facts. Yet, incrementalism is quite at odds with the coherent development of the law. To say that extensions of the duty of care should be allowed only incrementally is not to indicate the principles which determine whether such extensions should be allowed and in which cases. As Lord Bingham once observed, quote, "The incremental test is of little value as a test in itself and is only helpful when used in combination with a test or principle which identifies the legally significant features of a situation." End of quote. Additionally, the development of the law by analogy with established categories of case may well reflect arbitrary features of previously decided cases, rather than the essential merits of the claim or the underlying principles of justice. In practice, incrementalism, at least in England, too often takes the place of principled analysis and so leads to incoherence. Secondly, the incremental approach is buttressed by frequent judicial recourse to policy arguments. It's feared that a too rapid expansion in the scope of liability may open the floodgates of litigation or result in deleteriously defensive practice or have other undesirable consequences. So, to avoid these outcomes, the House of Lords, now the UK Supreme Court, frequently invokes policy arguments, but on an ad hoc and instrumental basis, to justify the creation of large no-duty or limited duty areas in which tort liability is excluded or arises only exceptionally. But there's little consistency in the way the policy arguments are deployed. For example, the floodgates argument. According to Lord Bridge and McLaughlin and O'Brien, it's always been, quote, greatly exaggerated. end quote. But in the same case, Lord Wilberforce considered the argument of sufficient weight to make it necessary to restrict this duty of care in nervous shock cases by laying down proximity restrictions in advance. Just because shock, in its nature, he said, is capable of affecting so wide a range of people. Later decisions also take divergent views as to the weight to be attached to the floodgates argument. A second frequently invoked policy consideration is the risk of overkill or detrimentally defensive conduct. This has led the courts to deny a duty of care in several high-profile cases, but a number of judges have nevertheless expressed skepticism about the weight properly to be attached to it. To cite a famous example, in Home Office and the Dorset Yacht Company, Lord Reid memorably dismissed the suggestion that British public servants might be so apprehensive, easily dissuaded from doing their duty, and intent on preserving public funds from costly claims that they could be influenced negatively in their conduct. My experience, he commented, leads me to believe that Her Majesty's servants are made of sterner stuff. A third example is the denial of a duty of care on grounds of a potential conflict of interests between the defendant's duty to the claimant and the defendant's more important duty to someone else. This was the basis on which the House of Lords rejected any duty of care on social services, child care providers to the parent of a child taken into protective care. There was a potential conflict between the interests of the child and the interests of the parent, and the paramount duty to the child precluded any duty to the parent. Yet, equally obvious conflicts of interest and duty are tolerated in other contexts. For example, the conflict between the duties owed by an advocate or an expert witness to the client and the duties that such persons owe to the court. In the absence of real evidence about the effects of the imposition of a duty of care on potential defendants, reliance on such policy arguments can only be speculative and intuitive. The law consequently degenerates into a set of barely connected pockets of liability without concern for principle or coherence. The instrumental use of policy considerations is one aspect of a third manifestation of the preoccupation with certainty. This is the pursuit of bright-line legal rules defining categories of duty, limited duty, and no duty. The existence of a duty of care is treated as a question of law, the question of notional duty, distinct from factual questions relating to the foreseeability of harm. So there's no duty of care in respect of distress or anxiety short of psychiatric illness, no matter how foreseeable, and only a limited duty in respect of psychiatric illness when it is in fact sustained. A limited duty also applies to pure economic loss and harm caused by omission rather than positive act. The perceived advantage of this approach is that it allows the preemptive striking out of claims where no arguable duty is owed and facilitates appeal court scrutiny and guidance of first instance courts. It's easier, for example, to reverse for an error of law than an error of fact, or mixed fact and law. The approach is open to criticism, however, for transforming the judicial role from adjudication to legislation. First instance judges are no longer free to make a nuanced assessment of how fundamental principles of justice should be applied to the proven facts of individual cases on the basis of direct witness testimony. Instead, appeal courts make abstract rulings applicable to broad categories of case. No duty is owed here, no duty of care is owed there. It's only owed in this third category of cases. This is doubly undesirable when it results in the striking out of claims on grounds of policy rather than principle, because, as I've already noted, the judicial capacity to assess and implement policy is open to serious question. One final point should be made as regards the incoherence that results from the judicial preoccupation with certainty in tort law. That's the pronounced passivity shown by the UK judiciary in the face of blatantly unsatisfactory outcomes in tort cases, accompanied by an undue readiness to say that the responsibility for addressing the problem lies with Parliament. The decision of the House of Lords in White and Chief Constable of South Yorkshire Police represents a particular low point in this regard. Faced with claims of post-traumatic stress disorder by police officers caught up in the Hillsborough football stadium tragedy, the Law Lords found the law of nervous shock to be so far beyond judicial repair that the only sensible strategy for the courts was, in Lord Staines's words, to say, quote, "thus far and no further," and by and large to leave any expansion or development in this area, in this corner of the law, to Parliament. End of quotation. And as Lord Hoffman observed, quote, "the search for principle in this area of law has been called off," end quote. In itself, this is a depressing admission of impotence. Even a child knows the maxim, "you broke it, you fix it." But worse was to follow. Lord Staines's "thus far and no further" dictum was invoked in the Lord's later plural plaques decision, declining to extend liability to a person exposed to asbestos and suffering psychiatric illness from fear of the possible consequences in future. But just 5 months before that decision, the Department of Constitutional Affairs had published a consultation paper in which it recommended that the courts continue to take responsibility for developing the law of liability for psychiatric injury and ruling out legislation in this area. So we seem to be caught in this game of pass the parcel in which the music never stops and no one gets closer to unwrapping the fundamental principles of justice upon which rational legal development turns. This analysis demonstrates, I think, that the pursuit of certainty in tort law results in a lack of coherence. It's also counterproductive, as it has in fact produced a high degree of uncertainty, even obscurity in practice. And this is evident from the repeated visits to the House of Lords or Supreme Court that have been necessary in many contexts in recent years, often without any final resolution of the disputed issues. A few examples should make this clear. First, since 1995, we've had 4 trips to the Lords to determine the liabilities of childcare professionals: Exon Bedfordshire, Barrett and Enfield, W and Essex, D and East Berkshire. Yet we still have uncertainty about fundamental questions. Is a duty of care owed to a child whom the care professionals decide to leave in an abusive home? Is it even clear that there's a duty of care in respect of a decision to take a child perceived to be vulnerable out of the family home and into care? On that latter question, the Court of Appeal thought that there was a duty of care in the last case to reach the Lords, D in East Berkshire. And the Law Lords appeared to agree, but the reasoning seems questionable, and the existence of a duty of care to the child in such circumstances has been regarded as at least open to question. Secondly, there's the liability of the police. In 20 years, 3 police negligence actions reached the House of Lords: Hill and Chief Constable of West Yorkshire, Brooks and Metropolitan Police Commissioner, Smith and Sussex Police. In all these cases, the House of Lords ruled that no duty of care arises in respect of the police's investigation of crime, whether to a potential victim or, in the Brooks case, a witness. Again, significant uncertainties remain. For example, the last case of the 3 leaves open the question whether the police owes a duty of care in respect of their performance of operational tasks, for example, concerning public safety on the roads. Established Court of Appeal authority says that they do not, but that may now be open to challenge on the basis of the Law Lords' dicta. Thirdly, we come to wrongful conception. In a dozen years, we had 3 major decisions, 2 of them in the House of Lords, McFarlane and Rees. The third case, Parkinson, did not reach the Lords, so the issue it raised, whether damages for wrongful conception extend to additional costs attributable to the unwanted child's disability, remains unresolved. The matter was discussed subsequently in Rees, but the law lords expressed divergent views, so here too we have uncertainty. Finally, we may turn to the law of nervous shock. In just over 20 years, we've had at least 6 House of Lords decisions. These have in no way improved the law as previously laid down in McLaughlin and O'Brien in 1985, a decision in which the majority of the House of Lords adopted a commendably flexible approach to establishing a duty of care, only for a later panel of law lords to reinterpret the decision to reflect Lord Wilberforce's more rigid minority approach in that case. Apologies to Donal, who I know has a different interpretation of that case. Again, significant uncertainties remain in the current law, in particular about the correctness of the approach taken to primary victims based on the decision in Page and Smith, which has recently been doubted in more than one decision of the House of Lords. The unsatisfactory nature of the present law has also been repeatedly acknowledged by the courts. In truth, the search for certainty in an area of law where so much depends on judicial assessments of what's reasonable is as likely to succeed as a judicial attempt to catch a moonbeam. Uncertainty is the inevitable result of the instability of the concepts employed. Apparently firm boundary walls are prone to subsidence because of the insecurity of their foundations. On thorough scrutiny, many duty-restricting rules prove to be based on foreseeability or some variant upon it. For example, knowledge, which lies at the heart of the narrow ratio of the leading case, Caparo and Dickman. Knowledge is simply foreseeability of a greater degree than that which is normally required, at least if one accepts imputed knowledge, and it remains a question of fact for the tribunal of fact in every case. A rule based on knowledge, actual or imputed, can never bring the hoped-for certainty. But Caparo and Dickman demonstrates that the power of a Supreme Court decision is not limited to its narrow ratio decidendi. The message that it sends to lower courts and to litigants is equally and perhaps more important. Thus, after Caparo and Dickman, first instance judges and the Court of Appeal took a notably more restrictive approach to the scope of the duty of care in respect of the preparation and certification of company accounts than had previously prevailed. A more recent decision that's had a comparable impact is Tomlinson and Congleton Borough Council, whose narrow ratio decidendi relating to the Occupiers' Liability Acts seems in retrospect, and was probably envisaged by its authors at the time, to be less important than their general remarks about compensation culture and the need to be vigilant against a decline in notions of personal responsibility in addressing the issue of breach of duty rather than the existence of a duty of care. Although the House of Lords analysis of the duty issue was rather technical and may perhaps be considered unpersuasive, the main message that the case sent to lower courts and to potential litigants was powerful and unambiguous, and it's been very influential. This suggests that the role of a final Court of Appeal may most usefully be conceived of in terms of setting the tone for first instance decisions and steering the lower courts back into line when their decisions begin to move in the wrong direction. It seems not to be productive to seek to constrain the exercise of judgment by first instance judgments by laying down detailed, precise legal rules that specify in detail the proper scope of the duty of care. Experience shows that gaps will inevitably remain, and it's more important to state the principles according to which the existence of a duty of care should be determined, including the factors to be weighed, than to strive for a certainty that can never be attained when the effort to attain it is liable to produce incoherence and injustice. That's what I think. Thank you.
Well, thank you very much, Professor Oliphant, for that interesting perspective on law of torts in England and duty of care. Unless there are some interventions for clarification, I will now turn this over to Professor Nolan.
Okay, well, the title of my paper is Deconstructing Duty. And by duty here, I mean the duty of care. When I say deconstructing duty, I don't mean subjecting it to semiotic analysis in the tradition of the French post-structuralist philosopher Jacques Derrida. I just mean taking it apart. There has been considerable divergence in the development of the duty of care in different common law jurisdictions. My main focus, like Ken's, is going to be on English law, and that is particularly important when I'm criticising judicial reasoning, that my focus is on English law. So the existence of what is termed a duty of care is generally regarded as a fundamental building block of the common law of negligence, analytically anterior to the other building blocks of fault or breach of duty, damage, causation, remoteness, and defences. This duty orthodoxy is deeply ingrained in the mindset of common lawyers, and it profoundly affects the way in which judges decide negligence cases and lawyers more generally think about negligence law. Nevertheless, the theme of this conference reminds us that an important task of the legal academic is to challenge such orthodoxies. And in my paper, I subject the duty orthodoxy to critical review and conclude that the duty of care concept is now obscuring understanding of negligence law and hindering its rational development. I therefore propose the deconstruction of duty, a process whereby the disparate issues currently subsumed under the duty heading are separated out and reclassified under the other components of the negligence inquiry. So a sort of taking apart or dismantling of the duty of care. Now, before I develop the substance of my argument for the deconstruction of duty, I would like to make 4 preliminary points. The first point is that duties of care are not duties. So the first point is that the duty of care isn't actually a duty at all, so that the term duty of care is a misnomer. A duty is an obligation, and in private law, duties are obligations owed to other persons. As Hofeld told us, a duty owed to another person correlates with a right which that person has against the duty holder. It follows that if the duty of care were really a duty, then we would all have rights good against everyone else, that they not create unreasonable risks of certain kinds of interference with our bodily integrity, property, and so forth. In fact, however, we have no such rights, because negligence actions arise only if and when the defendant's unreasonable risk creation results in damage to a legally protected interest of the claimant, such as a broken limb or a damaged rear bumper. And it follows that the wrong in a negligence action is the negligent injuring of the claimant, not the failure of the defendant to conform his or her conduct to the standard of a reasonable person. The duty of care is therefore, as Buckland pointed out in 1935, a myth with no corresponding right. Now, the second connected point is that skepticism about the utility of the duty of care concept is not inconsistent with a rights-based analysis of negligence law. In recent debates about the duty of care, there has been a tendency to equate it with the primary duties not to negligently injure others, which, along with correlative primary rights not to be negligently injured, underpin negligence law on a rights-based analysis. This is, however, a false equation, because these primary duties would by definition have to encompass all the elements of the negligence inquiry, and therefore skepticism as to utility of the duty of care concept, which is merely one element of the negligence inquiry, does not entail rejection of a primary duty right model of negligence liability, any more than scepticism as to the utility of a particular element of the tort of battery entails rejection of a primary duty right conception of that tort. The third preliminary point is what I'm calling the dual role of duty, which Ken has already touched upon. So the third point is that it's widely acknowledged in the academic literature that the duty inquiry deals with two different questions. First, whether damage to this claimant was a reasonably foreseeable consequence of the defendant's negligence. We can call that the factual duty question. And secondly, whether there's a rule of law which either allows or bars recovery in this category of case. We can call that the legal or notional duty question. It seems to me, however, that modern commentaries on the duty concept tend to be characterised by an undue emphasis on one or other of these two questions, with the result that at times protagonists in debates about duty seem to be arguing at cross purposes. In particular, scholars advocating an approach to negligence law centred on concerns of interpersonal justice tend to emphasise the factual duty component of the duty of care, which they argue demonstrates that negligence is a relational concept. Equally, adherents of a more instrumentalist or policy-focused approach to negligence tend to emphasise the notional duty element, which they characterise as a control device employed to limit the scope of negligence liability for policy reasons. By contrast, I argue that highlighting the dual role which the duty concept plays in the modern law of negligence paves the way for a rational exploration of its utility. And that brings me to my final preliminary point, which is that the duty of care question is not analytically anterior to the question of fault. The orthodox assumption that it is both reflected in and reinforced by the labelling of the fault issue as breach of duty, even though it follows from the fact that the duty of care is not a duty, that faulty conduct is not a breach of duty either. And this mislabelling of the fault question obscures a number of important truths. One of which is that sometimes the existence of a duty will depend on what precisely the breach of duty is, so that the judge must identify the alleged fault of the defendant before he or she can answer the duty question. Indeed, this is always the case, it seems to me, when it comes to duty in fact, because there the question is whether the risk of injury to this particular claimant was one of the risks that made the defendant's conduct negligent, a question which can't be answered until we know what the allegedly negligent conduct was. So we have to look at what the breach is before we can decide the duty issue. And once we appreciate that duty issues are not analytically anterior to the question of fault, that then paves the way for a deconstruction of duty in which those issues can, if appropriate, be reallocated to other stages of the negligence inquiry, including not only the fault stage, but also the stages which logically follow it, namely damage, causation, remoteness and defences. That process of deconstructing duty, I think, must begin with a closer examination of the notional duty of care. Now, I've defined the notional duty of care as the question of whether there's a rule of law which either allows or bars recovery in this category of case. And that definition tells us two things. The first is, this is really important, that the sole defining characteristic of notional duty is that it is a question of law. That is the only thing that limits what we can make a question of notional duty. The sole defining characteristic of notional duty is it's a question of law. And secondly, precisely because notional duty is by definition a question of law, notional duty decisions, in the words of a leading English textbook, transcend the particular dispute and concern whether, and if so how far, the law of negligence should operate in a situation of a particular type. So notional duty decisions have to be on a categorical or general level. They can't be too fact specific. They can't just be on this particular case. Now, it follows from these two core features of notional duty that it is an extremely open-ended concept, because as long as an issue arising in a negligence case is capable of being framed in these general or categorical terms, then it's capable of being classified as a duty question, regardless of its substantive content. And in this sense, as the late Tony Weir pointed out, duty is an operator, not a real number. Now, Weir drew that, I think, brilliant mathematical analogy in a note on a case called Reeves and Commissioner of Police of the Metropolis, a case which provides an excellent illustration of the open-endedness of notional duty. Reeves concerned the suicide of a man while in police custody, which his widow alleged was the fault of the police for failing to take certain precautions despite knowing that he was a suicide risk. And at first instance, the judge held that the police owed the deceased a duty to take reasonable steps to prevent him from committing suicide. So the judge held at first instance that the police owed him a duty to take reasonable steps to prevent him from committing suicide. Now, before the House of Lords, the police conceded the existence of a duty of care framed in those terms and also a breach of that duty, but they nevertheless argued that they were not liable for two reasons, or at least two reasons. First, because the act of suicide was a novus actus interveniens, which broke the chain of causation between their negligence and the deceased death. And secondly, because the defence of valenti applied. As the House of Lords pointed out, however, this made no sense, because if the police owed the deceased a duty to take reasonable care to prevent him from committing suicide, then the mere fact of the suicide could not absolve them from legal responsibility for their failure to take reasonable care. In other words, by framing the notional duty issue in the way that he did, the trial judge had subsumed any arguments from legal causation and valenti raised by the suicide into the duty question, with the result that if the defence wished to rely on those arguments, they had no choice but to attack the judge's decision on duty. As it is, the position which they adopted was self-contradictory, and therefore they lost the case. So that illustrates, I think, Reeves a clear illustration of the way in which issues can be sucked into notional duty by characterising them in a particular way. What I want to do now is just quickly look at what I regard as being the core of the notional duty question, the traditional core of that question. And it seems to me that that is really two things. So the first is the issue of protected interests. And the issue of protected interests is accommodated within the duty framework by formulating the duty in terms of the nature of the interest invaded. So we ask, was there a duty of care in respect of psychiatric injury, pure economic loss, and so on. In addition to that core concern with protected interests, notional duty has also been the traditional repository of the various immunities or special protective rules which have been recognised by the law of negligence over the years. So that, as it were, is the core, it seems to me, of notional duty. But the open-endedness of notional duty, coupled with the fact that its classification as a matter of law renders it an effective mechanism of judicial control, a point which Ken touched upon, has meant that over time issues which have previously been dealt with at other stages of the negligence inquiry have increasingly come to be dealt with under its rubric. And a good example of such an issue is the effect of deliberate intervening conduct. Traditionally dealt with as a matter of legal causation by asking whether or not it was a novus actus interveniens, but now generally addressed, as in the Reeves case, by asking whether the defendant owed the claimant a duty of care which extended protection against conduct of this kind. Similarly, while a negligence action brought by a claimant who is engaged in a criminal activity at the time of the alleged tort has in the past been met by a defence of illegality, the courts may now dismiss such an action, and increasingly do so, on the grounds that the illegal conduct prevented a duty of care from arising in the first place. So there's been this sort of move of these issues out of other areas of the inquiry into the notional duty question. That's partly because of the open-endedness of it, and partly because it gives appellate court judges more control if they characterise these questions as duty questions. All of that, in a sense, I'm afraid, is a sort of setting of the scene, because it brings me to the heart of my paper, which concerns the process of deconstructing duty and the arguments for doing so. Now, the actual process of deconstructing duty seems to me to be relatively straightforward. An obvious starting point is the separation out of factual duty and notional duty. And since the factual duty question is whether or not the risk of injury to this particular claimant was one of the risks which made the defendant's conduct negligent, that's the issue in Powell's graph, that's the issue in Borhill and Young. That factual duty question, I think, should be dealt with at the remoteness or scope of liability, however you want to call it, the Americans would call it proximate cause, stage of the negligence inquiry. And that's a reclassification which is already advocated by many other scholars. So not in itself perhaps hugely controversial, but no doubt there are some who disagree. We turn to notional duty. I suggest that where an issue has sometimes been dealt with under the notional duty heading and sometimes dealt with at another stage of the negligence inquiry, deconstructing duty simply requires that the issue be allocated to that alternative heading. So deliberate intervening conduct is dealt with as a question of legal causation, illegality is treated as a defence, and so on. And that leaves then the core questions of notional duty as I see it, which is protected interests and special immunities. If we begin with the immunity rules, it seems to me that the key to the reclassification of these, and I have in mind rules, for example, like the rule which I know certainly is part of Australian law and also English law, which gives immunity in respect of combat operations, physical damage caused by positive action. In a combat operation, there is immunity. Those kind of rules, I think the key to reclassifying them is that in practice it's up to the defendant to establish that the case for such a rule is made out. And that is reflected in the way that the two-stage ANDS test works. It's reflected in the way that the three-stage Caparo test works, I think. And this is something that Andrew Robertson has highlighted in the operation of these kind of tests and the duty inquiry, that effectively the burden here with these immunity rules lies on the defendant. Therefore, it seems to me they are best understood as defences to negligence liability, which at the moment are wrongly classified as going to the existence of an element of the cause of action. So I would treat these immunity rules as effectively defences, and I think there's some support for that in some of the writing and in the United States and some of the judicial reasoning in the US. That leaves only the protected interest question, which I think is the tricky one. The first step here would be to separate out, in my opinion, the first step should be to separate out negligence cases concerning core rights which are held against the whole world and those concerning acquired rights which are only held against particular individuals. A relevant contract, fiduciary relationship, assumption of responsibility may enlarge the range of interests protected against negligent interference to encompass things like pure economic loss. That is certainly the way that the English judges have developed this. And therefore, it seems to me, certainly in England, analysis of the protected interests issue would be more focused if we drew a clearer line between core and acquired rights as part of this process of deconstructing duty. So that is the sort of first stage in dealing with the protected interest question. As for the protected interest question in core rights cases, which can't be, as it were, explained away by reference to some kind of acquired right of assumption of responsibility, how do we deal with that without a duty inquiry? Well, there seem to me to be two possibilities there. One possibility would be to push that issue into the element of damage, so that, for example, in the absence of an acquired right, pure economic loss would simply not be recognised as a form of damage for the purposes of negligence liability. Now, I think one can just about do that on the English law. I think it would be much more difficult to do it on the law in other jurisdictions, because it would be more difficult to formulate the law as it has developed in such bright line terms. But I think that's almost achievable in England. The other way of doing it would be to accommodate this protected interest question within a negligence inquiry without duty. One could do that by developing a new element of the cause of action focused entirely on this question of wrongfulness, which would be analogous to the list of protected interests in paragraph 823 of the German Civil Code. Personally, I think the damage route is probably a better one for various reasons which I explore in the paper. But it seems to me that those are perhaps the two possibilities there. The next question, a fairly obvious one then, is why do this? Why deconstruct duty? After all, does it really matter how we choose to package up the substantive issues which arise in negligence litigation? Well, the answer to that question seems to me to lie in John Fleming's observation that the respective suitability of the different concepts employed in negligence cases can be assessed only by reference to the degree to which they impair or assist forthright adversion to the real issue before the court. And with that observation in mind, that I put forward a number of reasons why I think that deconstructing duty would improve the quality of reasoning in negligence cases and indeed our understanding of negligence law more generally. Now, I'm conscious of time. I'll just highlight the most important of those arguments now. The first one is that but they're explored in more depth in the written paper. The first is that deconstructing duty would produce a more structured and focused inquiry on any matters of law arising. So my central argument for deconstructing duty is that dealing with a wide variety of distinct issues under the notional duty umbrella means that different problems get muddled, and that separating those issues out would better enable the courts to address the central questions of law raised on the facts of a case. So if, for example, we have a case involving deliberate intervening conduct where there are also some policy arguments that are being made against liability, it seems to me that it would make more sense to deal with the third-party issue first and then to look at the policy considerations separately. At the moment, the fact that the two issues both fall under the heading of duty and notional duty means that sometimes they may not be properly separated out. Second argument for deconstructing duty is that it would allow similar issues which currently arise at different stages of the negligence inquiry to be dealt with alongside each other. So, for example, separating out factual duty would enable it to be considered alongside the analogous questions which arise at the remoteness stage of whether the type of damage suffered and the manner of its infliction were foreseeable consequences of the defendant's negligence. Those three questions, the foreseeability of the claimant, the foreseeability of the type of harm, and the foreseeability of the way it was inflicted, could be dealt with together as part of a sort of scope of the risk or scope of liability inquiry. Another argument I put forward for doing this is that it would avoid the unhelpful confusion of issues of law and fact. An unfortunate consequence of the duty mechanism is the well-known phenomenon of courts mistakenly categorising factual questions of fault as issues of duty by formulating the notional duty question in an overly specific way. I have in mind a kind of decision where it said that the driver of a car didn't owe a duty of care to stop at the traffic light or whatever it is. This is I think it's clearly an error in the sense that because the defining characteristic of notional duty is a question of law, you have to be able to express this at a categorical level. These questions of fact don't belong there, but this is an area that does happen quite frequently, particularly at the lower levels of the judiciary. And I think that the difficulty here is the inherent ambiguity of the duty concept creates this possibility of this kind of confusion of questions of law and fact. Two more arguments which I think I should mention. The next one is that the malleability of the duty question causes confusion and incoherence. So it seems to me that one of the disadvantages of the duty of care concept is that the duty question can be formulated at very different levels of generality. And to give a flavour of this, I list a number of formulations of the notional duty question in my paper, just taken from recent English cases. And you can see, I think, from those examples, just how flexible this mechanism is in terms of how one expresses the duty question. But the malleability of the duty question as revealed by those examples, I think is a problem for three reasons. First of all, because it makes it difficult to summarise the law in a given field of negligence with any precision. Secondly, because it creates a danger that a court will overlook an earlier duty decision, which is either resolved or is closely analogous to the central question of law raised by the facts of the case. And I give some examples of that. And thirdly, because the tendency revealed by at least some of these examples to formulate the duty question in an overly specific manner threatens to return negligence law to the wilderness of single instances which characterised the field before the great generalising decision in Donoghue and Stevenson. So I think that's actually an important point. It's just really a point about the way in which the duty question is phrased or is put. And frequently my sense is that this is not something that the judges themselves decide, that it's about how the case is pleaded. And so if a case is pleaded in a particular way, the duty is framed in a particular way by counsel, then the judge says, well, that's the question I have to decide. And there's no sort of overarching sense of what level of generality that question is addressed at. My final argument for deconstructing duty is that a disadvantage of treating duty as an element of the cause of action is that it fosters the belief that it's possible to come up with a meaningful general test for duty, despite the fact that the open-endedness of notional duty is such that any general formula will inevitably be so abstract as to be devoid of practical utility. And what Fleming called this futile quest soaks up time and energy which would be better employed in considering the substantive questions which fall under the duty heading, while sometimes the use of general tests which have been put forward masks a failure to address those questions in a meaningful way. I will be brief because I'm conscious of time. Just before I conclude, just one final question, which is what would we lose if we did this? And Ken has already touched upon this. Defenders of the concept of duty often focus on the characterization of notional duty as a question of law. So in particular, it's argued that deciding cases on notional duty grounds produces greater legal certainty because these decisions have precedential force, they can be expressed in categorical bright line rules and so on. Also, characterizing as a question of notional duty means it can be dealt with as a preliminary issue without going into the facts in detail. But I argue that these supposed advantages of the duty mechanism are largely illusory. Not really for the same reasons as Ken, because I don't necessarily want to make a case for or against certainty, but simply because even if you did deconstruct duty in the way that I'm saying you could, the issues which are currently dealt with under the notional duty heading could still, where appropriate, be treated as questions of law with all the potential advantages that that offers. So I don't think that taking things out of notional duty means that they necessarily have to become questions of fact, and therefore one loses those advantages if they are advantages of certainty. I'll just make two final points by way of a conclusion. The first is that any challenge to orthodoxy is likely to encounter resistance, and the duty of care concept is so firmly rooted in common law thinking that a call to abandon it is bound to be contested very strongly. Those who are minded to defend the duty of care would, however, do well to remember two things. One is that the concept in its current form emerged in the 19th century only because of a series of historical accidents. And the other is that no equivalent to the duty of care, as it has developed in the common law world, exists in civil law systems. Now, if civilian systems can do just fine without the duty of care concept, then it's hard to believe that it is really indispensable. And the second point is that although I argue in my paper for the complete deconstruction of duty, so that outside the prior relationship context, the concept is dispensed with altogether, the case for deconstructing duty is not an all or nothing one, as even a less radical move away from dependence on the duty concept would, I think, have beneficial effects. And a less drastic deconstruction of duty would, I suggest, require three steps to be taken. The first is the separation out of factual and legal duty. So I would put factual duty into the remoteness scope of liability stage, and that is, as I say, already very commonly done, particularly in the US. Certainly in the US textbooks. Secondly, where another existing element of the negligence inquiry has previously been used to deal with the question of law arising in a negligence case, I would say that the issue should, if possible, be dealt with under that heading rather than under notional duty. And then finally, when it comes to those core issues of protected interests and special immunity rules, what is important there, I think, is that they're properly identified and classified so that the notional duty inquiry which remains has a commonly agreed structure within which notional duty questions are dealt with at a fairly consistent level of generality. So without going as far as to dispose of duty altogether, I think those three changes would enhance the quality of reasoning in negligence cases and also the more general understanding of negligence law.